Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update on the recent arrest of former Jharkhand Chief Minister Hemant Soren. Last week, he was taken into custody by ED in a money laundering case linked to an alleged land scam. Before the arrest, he was questioned for over 6 hours by ED. An FIR was lodged last week by Jharkhand Police under the SC/ST Act based on a complaint by Soren concerning searches conducted by the ED at his Delhi residence. Hemant Soren in his complaint alleged that the ED search operation at his Delhi residence was conducted with the intention to harass and malign him and his community. He further claimed that ED officials had strategically leaked information to the media to create a spectacle aiming to tarnish his reputation in the eyes of the public. The ED officials who were implicated in the FIR have now approached the Jharkhand High Court in their personal capacity to contest the same. In a parallel development, the Jharkhand High Court today adjourned till 12th February hearing in the petition filed by Soren challenging his arrest for alleged involvement in the significant land scam. The Supreme Court bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra today heard the petition filed by Aam Aadmi Party councillor Kuldeep Kumar challenging the refusal of the Punjab and Haryana High Court to stay the Chandigarh mayor elections. After seeing the video of the controversial election in which a BJP candidate was declared the winner after the votes of 8 candidates of the Congress Aam Aadmi Party alliance were declared invalid, the court today came down heavily on the presiding officer who conducted the elections by orally saying that it was obvious that he defaced the ballot papers. The CJI said that the court was appalled to see the behavior of the presiding officer and that he could be seen making alterations in the ballot paper. Issuing notice on Kumar's petition, the court ordered that the Chandigarh Municipal Corporation meeting scheduled for 7th February be postponed. The court ordered that the entire record of the mayor election should be separated and be kept with the Punjab and Haryana High Court Registrar General and the ballots and videography be preserved. And the court also said that the Deputy Commissioner of Chandigarh, who has the possession of the records at present, should hand them over to the High Court Registrar General by today 5 p.m. The court directed the presiding officer to remain personally present before the court on 19th February to explain his conduct. Solicitor General of India Tushar Mehta contended that the video only showed one-sided picture and urged that the court should take a comprehensive view after seeing the entire records. The CJI, being critical of the High Court's order, said that it had failed to issue an appropriate interim order. In another update, the Supreme Court today adjourned the petition filed by Aam Aadmi Party member Shelley Oberoi, the mayor of the Municipal Corporation of Delhi, seeking a direction to exercise the functions of its standing committee till the committee can be properly and legally constituted. A bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra heard the matter today. The Supreme Court had previously reserved judgment on whether the Lieutenant Governor of Delhi can appoint nominated members to the MCD without the consent of the Delhi government. Senior advocate Dr. Abhishek Manu Singhvi, appearing for the petitioner, told the bench that the standing committee was performing various vital functions and any decision having an expenditure of 5 crores, including the midday meal scheme for the school children, has to go through the standing committee. He explained that the standing committee consists of 18 members, out of whom 6 members are directly elected by the corporation. The remaining 12 members are elected by an electoral college which includes 10 members who have been nominated by the Lieutenant Governor. According to the petitioner, the members nominated by the LG cannot be allowed to elect the standing committee members. Singhvi further told the bench that the Apex Court in May last year had reserved judgment on the issue whether LG can nominate members unilaterally without the consent of the Delhi government. The bench today posted the matter after 2 weeks. This matter arose from the Delhi government's petition to annul notifications through which the LG had appointed 10 nominated members to the MCD independently without consulting the Council of Ministers. As per the Delhi Municipal Corporation Act of 1957, these 10 disputed members are also entitled to vote in the standing committee elections. Given that this will substantially impact the elections, the committee has not been constituted yet. The Supreme Court today agreed to list the curative petitions filed by Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the Delhi liquor policy case. Senior advocate Dr. Abhishek Manu Singhvi, appearing for Sisodia, mentioned the curative petition before the CJI seeking urgent listing. In October last year, a bench comprising Justices Sanjeev Khanna and S.V.N. Bhatti had dismissed Sisodia's petitions seeking bail in the cases registered by CB and the Directorate of Enforcement over the Delhi liquor policy scam matter. In December, the same bench dismissed the review petition as well. Also, let me tell you, the Supreme Court has adjourned a plea by Aam Aadmi Party MP Sanjay Singh challenging his arrest and remand on charges of money laundering over the same liquor policy in Delhi. The Supreme Court today agreed to list the petition filed by Sunil Prabhu, member of Shiv Sena, that is the Uddhav Thackeray faction, challenging refusal of the Maharashtra Speaker to disqualify the MLAs of Shiv Sena, that is Eknath Shinde faction, under the 10th schedule of the Constitution. Senior advocate Kapil Sibal, appearing for the petitioner, mentioned the matter before the CJI that the petition was not listed today, although it was supposed to come up today as per the Supreme Court's direction on 22nd January. The SLP has been filed challenging the order passed on 10th January by the Maharashtra Legislative Assembly Speaker, dismissing the disqualification petitions filed by the Uddhav Thackeray group against each other. Speaker Rahul Narvelkar dismissed the set of disqualification petitions and held that the Shinde group was the real Shiv Sena on the ground that they had a legislative majority when the rival factions emerged in June 2022. The Speaker also recognized the whip appointed by Shinde as the official whip of the Shiv Sena party and held that there was no violation of the whip by the Shinde group MLAs. Uddhav Sena challenges that the Speaker's ruling violates earlier judgments of the Supreme Court by conflating the concept of legislature party with the political party. And now an update on the Bihar caste survey. The Bihar government conducted a caste-based survey that was launched on January 7th last year in order to digitally compile data on each family from the panchayat to the district level through a mobile application. After initially issuing a temporary stay in May on the caste-based survey being conducted by the Bihar government, the Patna High Court later upheld the exercise as perfectly valid, initiated with due competence, and dismissed the petitions challenging it. Now, a division bench of Justices Sanjeev Khanna and Dipankar Datta today heard an SLP against the High Court's decision. The Supreme Court has scheduled the final hearing of the matter in April. Notably, the court has consistently refused to pass any order of stay or status quo to restrain the state from publishing or acting on the caste survey data before hearing the parties at length. The hearing today was adjourned by the court summarily with an instruction to relist it in the week commencing from 16th April. The Delhi High Court has refused to quash the summons issued against Delhi Chief Minister Arvind Kejriwal in a criminal defamation case for retweeting an allegedly defamatory video posted by YouTuber Dhruv Rathi in 2018. The complaint against Kejriwal alleged that the YouTube video titled BJP IT Cell Part 2 circulated by Rathi was false and defamatory allegations were made in it. And Kejriwal retweeted the video without checking for its authenticity. Justice Swarnakant Sharma today held that retweeting defamatory content will attract the offence of defamation under Section 499 of IPC. The court upheld the summoning order passed by the magistrate and the order passed by the Sessions Court rejecting Kejriwal's revision plea against the same. The court held that online interaction on Twitter and sharing any posts with others by retweeting attracts the liability for the offence of defamation. It also said that ramification is far more than whisper when a public figure tweets or retweets something on social media. And lastly, in a matter pertaining to a single judge of Madras High Court taking suo motu revision against the discharge of Tamil Nadu Revenue Minister KKSSR Ramchandran in a corruption case, the Supreme Court today observed that the judge ought to have ideally placed the matter before the Chief Justice of the court prior to passing off the order. The court was hearing Ramchandran's challenge to suo motu cognizance taken by Justice Anand Venkatesh of the Madras High Court against his discharge in a corruption case. The allegation against Ramchandran in this case was that he, along with his wife and friend, accumulated wealth disproportionate to his sources of income while serving as a minister between 2006 and 2011. After hearing submissions addressed on behalf of Ramchandran and seeing the report submitted by the Registrar General of the Madras High Court, the bench of Justices Rishikesh Roy and Prashant Kumar Mishra left it for the Chief Justice of the High Court to take a call on who shall hear and decide the suo motu proceedings initiated by the single judge. It was also clarified that the order passed today shall not be construed as making comments on the concerned judge handling the suo motu case. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.